Umeth Land versus Buffington et al.
We have Dave Hammock here with Houghton Perrin on behalf of the plaintiffs and movements on this motion to compel.
And Judge, this is Austin Jones of McGinnis Lockridge on behalf of defendant Delia Buffington in her capacity as personal representative of the estate of Thomas Buffington on the motion to compel. Although this is not our motion, I would like to raise something that may give back much of our 10 to 15 minutes of time because you may need it on the other one, Judge. But the long and the short of it is the motion that was filed today and the hearing that was set was filed and set in the wrong cause number. This is the second iteration of this lawsuit. There was
Okay, hold on. Let's start with what day was the motion filed? Because can somebody tell me that? Let me double check my phone.
Your Honor. And I'd be happy to address that before we get too deep in the weeds here. I have June 18th, 2026. Please.
There was no motion filed in this matter on June 18th. There's nothing filed in this case.
No, here's what we have, Your Honor, if I may. We have a clerical issue. There was an older version of this lawsuit that was non-suited without prejudice. So we have an old matter that was 2 years or so closed. And then we have what was refiled with the limitations period ran last year. We filed our motion to compel in the new matter. Inadvertently, the motion was filed in the old matter number.
So let me correct you for a second.
Yes, Your Honor.
You did not file it in the current case. You inadvertently, you said we filed our motion to compel in the new matter, but we've just established that there is no motion in this case, correct?
I think I misspoke if I said that. I'm sorry. It was filed. We intended to file it in the new matter. It was inadvertently filed in the old matter. Copy was served upon Mr. Jones. We conferred regarding the motion. We conferred regarding setting this for hearing. We secured a hearing date and time together for one that worked for both of our schedules. It is my understanding that hearings were set in both the old matter and the new matter on this same motion. My legal assistant was on the phone with court staff yesterday trying to figure out what happened,
What is the old cause number, please?
Yes, Your Honor. D-1-GN-21-003167. So
it's not linked. Hold on. 3176 or 67?
3176. Thank you.
So they're very closely, the cause numbers are very similar.
Yeah, and I think it was just an oversight, and that's my responsibility. I'll take responsibility for that. So what we think the thing to do is proceed with the motion. We're here. They're on notice. There's no prejudice. They had an opportunity to file a response. They chose not to.
Hold on, please.
Yes,
I'm looking at GN 21003167, and that is a completely different case.
3176.
That is the case that's set today in which the motion was not filed.
And that motion was filed in that matter number, as I understand it. That is the old.
Well, I'm telling you, I'm looking at it, and it wasn't.
It wasn't filed in that matter?
No.
Well, then we've got some bad information then. So then 5042, was it filed in that matter number?
I don't know what 5042 is, sir. What is set before me is GN 21003176. That's the case I called. There's nothing filed in June in that case. You gave me a cause number of GN 21003167 that has nothing to do with this matter.
I misspoke, Your Honor. I just swapped the last two digits. 3176, which is the same matter that you just announced a moment ago.
And I asked you a minute ago, did you mean 76 or 67? So what is the old cause number?
This is my understanding that this is the old cause number, Your Honor. I'm not trying to overcomplicate things. This is the information I have. This is the old cause number. The new cause number ends in 5042.
What's the full cause number? GN what?
D1GN 25005042. My understanding, and Mr. Jones, correct me if I'm wrong, that is the new and current cause number.
That is correct, Judge. The 25 D1GN 25005042 is the current cause number for the second lawsuit.
So it looks like the hearing that what is set and file and notice for hearing is the old cause number, which ends in 3176. If it shows that it wasn't filed, that's I don't know what to say to that, because it was confirmed to me that that's actually that it was filed.
Well, let me say, I found the new cause number, GN 25005042.
Right.
Nothing was filed in June. That case wasn't filed until July
Of 25. Right.
And
So
nothing has happened in that case since August of 25.
And it was our intent. It was our intention to file this motion to compel in that cause. It was inadvertently filed in the old cause number 3176. Are you saying that it's not, that isn't showing on your docket either?
It's on my docket. I can't find the motion is what I'm telling you.
Did my legal?
Oh, hold on. I stand corrected. I do see it. It was. I apologize.
Okay. So we're here on the motion that everyone understands which case it is, what it's about. We've conferred about it. There's no prejudice. We think the correct thing to do is to proceed with this motion and then resolve the issue of getting the right order on the right docket number and getting this motion just moved over from one cause number to the other as a clerical issue. If we could go ahead and proceed.
Mr. Jones?
I hate to be a difficult person in this, Your Honor, but the old cause number, it was non-suited in September of 2024. There's that the court under that cause number no longer has any jurisdiction to enter an order 2 years after the fact for discovery for the new lawsuit. We certainly have gotten his motion. We have supplemented our discovery last night. Mr. Hammock and I discussed this morning. We've continued to have conversations. The issue is the motion and the hearing is set in a case that has been closed for 2 years, where there's a whole separate lawsuit.
Well, and that's caused a whole problem. If you only knew the problems I have anyway with the new reporting requirements in the Office of Court Administration, the case that was set today, that is 21-3176, was closed.
Yes, Your Honor.
In September of 24. It shows as reopened. It now says for 100 and now it shows as opened.
That's strange.
No, well, no, it was only open till 24. It's still closed. So
that's consistent with my understanding. And Your Honor, again, I think this is an issue of form over substance. This is easily fixed. We proceed with the motion. We resolve it today. We get an order. We have a proposed order with the correct cause number. So if it's signed and entered, it will be put in the correct the correct cause number. And then all we need to do, to the extent that we even need to, is just move the motion and the notice of hearing from the one cause number to the other as a clerical.
Mr. Jones, I guess you can stand on that. It does seem like a complete waste of you all's time and the court's time if we're just going to take up the exact same motion that y'all have been conferring about and that you obviously have no notice of.
Yes, Your Honor, I do need to stand on my objection. I raised this issue with Mr. Hammock last week. I believe that's why we tried to get it figured out. But we have supplemented the discovery at issue. We've had conversations about it. This has not been for naught.
The issues are unresolved. These discovery requests have been pending for 4 months. We have 18 pages of documents.
Okay, I get it. Mr. Jones, I think, is entitled to stand on his objection. What I'll do is set you before me again real quick so you can get it filed in the right cause number. I mean, it does seem like form over substance if you've been conferring, but Mr. Hammock, you should have refiled your motion if you knew about it last week in the right cause number, and I would have moved forward. but you didn't.
Apologies, Your Honor. We found out Friday afternoon when Mr. Jones notified us and jumped on the phone immediately trying to get a resolution with the clerk, and that was not suggested, but I'm happy to do that.
Well, you filed it in the wrong cause number. The clerk can't take a case. So, all right, today's Tuesday. When do y'all want to reset this before me on a Zoom?
Whenever the soonest available 10-minute hearing slot that we can get.
If you waived 3 days notice, I'll do it Thursday. If not, I guess I could do it Friday morning.
Judge, I am scheduled to speak at a government law CLE Wednesday and Thursday in San Antonio. And then
You want to do it Friday?
I have a trial setting in Williamson County on August 3rd, and we are to report on Friday.
What time do you report on Friday?
We have a conference in the afternoon, so if we can do it in the morning on Friday.
Okay, what time? Let's do it in the morning on Friday. Why don't we say 10 o'clock? Does that work for you all?
Yes, sir.
Chambers, can you calendar that? You'll get
Will it be via Zoom?
Yeah, via Zoom, right? Do you all agree?
Yes, Judge. Zoom is
All right,
perfect.
get the motion refiled, Mr. Hammock, in the correct cause number today. We'll take it, and if we still need this hearing, we'll take it up Friday at 10 on Zoom. If y'all continue to talk and can resolve it, that would be great. If not, I'll see you Friday morning at 10 a.m. on Zoom.
Thank you.
Thank you.
Dave Hammock with Houghton Parent on behalf of the plaintiffs.
All right, you all were in front of me on Tuesday for your motion to compel, Mr. Hammock, at which point, it was a remote docket, as I recall. At which point, Mr. Jones pointed out that your motion to compel had erroneously been filed in the wrong cause number. Mr. Jones tells me he saw that you have refiled it in the correct number, right?
Correct. That's correct.
I don't see a copy of it, but I guess.
So my legal assistant was working with the staff. It had been filed. It has not been accepted yet. I believe that she submitted confirmation yesterday via email, just with courtesy copies of everything.
Yeah, that's fine. Mr. Jones tells me he saw you file. That's fine. I've gotten myself confused. Am I supposed to be looking at I have something marked in my file as in the GN 21003176 case as plaintiff's motion to compel filed 6/18. Is that basically the motion we're talking about?
My understanding, Judge,
Yes,
it was the same exact substance, just with the correct cause number.
Also, I realized I didn't give an instruction that I should have, which is we're here on Zoom because the parties agreed to do Zoom. I reset this from a Zoom hearing on Tuesday. In order to comply with the open court's provision, we are live streaming today's hearing on the court's YouTube channel. Just as if you were in the actual courtroom, no one who is in the Zoom courtroom, nor anyone who might be watching the court's YouTube channel, is permitted to make any recordings whatsoever of today's hearing. If I were to find out someone did that, they would be subject to a finding of contempt of court. All right, with that, I'm ready to begin. All right. Mr. Hammock.
Yes, if I may share my screen, Your Honor.
You may.
All right, is that visible on your end?
Yes.
All right, Your Honor, fortunately, this is a pretty brief proceeding. This is a complicated lawsuit with a lot of parties. Fortunately, for our purposes here, these facts are straightforward. Mr. Jones represents the estate, which is represented by the estate's executor or an administrator, who's referred to as D, colloquially. This relationship between plaintiffs and the estate is governed by a pledge agreement. There's no dispute that that's valid and enforceable. The estate does not deny that it owes money under the plaintiffs or under that pledge agreement. So the only question is, how much does the estate owe? And so for months now, we have been working on trying to figure this out. So in August of 25, Mr. Jones and I started talking about this informally to see if we could just figure it out and work it out. That stalled. We worked on that from August of 25 to March of 26. And in a moment, we'll talk about the reason for that length. Big reason being is that Dee is elderly. And so obtaining information and documents from her has been a challenge. And that's understandable. She's, I believe, in her 80s. So what Mr. Jones and I have been talking about is, all right, how do we work around that? In February, Mr. Jones mentioned that there is an accountant who would be a source of information to get conclusive answers to these questions. We talked about it in February. The accountant was traveling. We talked about it in April. He said, we're in tax season. But still, as far as I know, I don't know that we have obtained any information from an accountant or a wealth manager or a banker or any of these individuals who would otherwise act in a representative capacity on behalf of the estate, who certainly have access to bank records, financial statements, tax returns, so on and so forth. So on March 6th, plaintiffs went ahead and served discovery. We kept it pretty narrow, 19 ROGs, 23 RFPs, 17 RFAs. Responses were due in April, and what we were served at the time was a will supplement, promises of production, request for a brief extension, which we granted. That's okay. Let's work together and get this worked out. A promised doc production in writing by May 6th. May 6th comes and goes. We don't have a supplement. We don't have a doc production. About a week later, we got 4 documents with a promise of more. And at the time that I prepared this, just before the last hearing, we got an additional 14 pages of documents for a grand total of 18 pages of documents in response to all of this. And I'll show you in a moment that quite a few of the amended responses still say will supplement in response to some core questions here. We file our motion to compel in June. Now we're here on this motion. In between, Mr. Jones and I have had repeated correspondence with email and phone. I'm still working on it. We're still working on it, having trouble getting documents together. And now here we are. And what I wanted to provide are a couple examples of just going straight to the amended responses. Here we go. So these are the supplemental objections and responses that we received on Monday morning, I believe.
Hold on.
And
you haven't moved your PowerPoint. I still see timeline, the discovery. You just needed to move down on your PowerPoint to the next page, I think.
Can we see this PDF?
Yes.
Okay. So here are the supplemental objections and responses that defendant Delia Buffington served on behalf of the estate just before the hearing earlier this week. And unfortunately, we still have some issues here. Mr. Jones and I have communicated since then, talking about, hey, does this narrow the scope? And yeah, it does to an extent, but we've still got some key missing information. So now finally, we have some financial information about what, at least in an interrogatory response, that the estate says they received. These aren't verified, and so, and particularly at this point, this is great. Thanks for this information. We need to corroborate this with some specifics, specifically with bank account information, financial accounts. Hey, okay, great. You're telling us these are the numbers. We need to corroborate that, please. Give us some bank accounts. Give us financials. Help us identify where these funds were deposited, where they may be, and we are still will supplement. We have an objections, copy-paste objections to the undefined terms, but no indication that that's actually precluded them from getting this information. We have a request as a part of that workaround. All right, Ms. Buffington is elderly. Well, then tell us who the accountants, financial planners, tell us somebody else that we might be able to reach out to directly and get this information. And we know that there's at least one accountant. We don't have identification responses. We have a refer to their initial disclosures, which isn't really an answer. And those initial disclosures do not identify any of these types of folks. We have some requests for communications. Frankly, those are secondary to our concerns about the financial records themselves. We now go to the request for production. bank statements, et cetera, showing the deposit of sales proceeds, which would allow us to corroborate their statements regarding how much was actually owed. Will supplement. Same here. Legal, accounting, financial advice relating to this will produce. We don't have those. And we have a lot of, I wanted to point out, will supplement if any. We haven't found any, but will supplement if any. Well, the rules require an affirmative statement that you've either found them and will produce them, or you haven't found them. And obviously the duty to supplement is ongoing. But responses like this raise concerns that, look, are we still looking, or have we looked and not found anything? Because these are different things. So, same spot where we were essentially in August of last year. We finally have at least a number as to what they contend is owed, which is essentially what they are contending. But we still need to be able to corroborate that to meaningfully move forward. And this is discoverable information. This is well within the scope of discovery.
Now I've lost your audio and I can't hear you.
Did you lose me?
There you are. Now you're back.
Please.
I also lost it.
Can you hear me?
Yes, now we can, but the last thing you were saying, we didn't hear you.
Your Honor, Austin, can you hear me?
We hear you. Can you hear us? You can hear us.
Is that better? Can you hear me all right?
Yes, that's
I show
fine.
that I'm dialed in. Can you hear me?
Yes, we hear you. You
can
can't
hear me.
us.
No, I cannot. No, I don't know why. Can you still hear me? Can I hear you now?
Yes.
I'll proceed then as best we can here so that we don't run into any issues.
Can you hear me?
I'm sorry, no, I can't. I don't know why. I could hear you a moment ago.
I have no idea. I haven't touched anything. I think it's all on your end, Mr. Hammock.
There we go. There we go. It just reconnected. All right. We're good?
Can you hear me?
I can't. Okay. I got to talk to our IT guy after this. Okay. Did you hear everything I said up to the point where we're in the same point we were in? Okay, we're at the same point we were in August. Okay. To address what I expect, so for that reason, we're seeking an order within 10 days. Let's put a date certain. Let's be done. Let's get full compliant responses that track the language of the rule. Let's withdraw some of these boilerplate objections if we need an order overruling them. I'm happy to go into further detail there, but I showed you the types of examples that we're talking about. They don't appear to actually withhold production, which means they're prophylactic, which means they're invalid objections. To address what I expect Mr. Jones may bring up, he filed a response late last night. I don't know whether it's been accepted by the court or before the clerk or before the court right now. He essentially raised 2 points. One is about Ms. Buffington's age and how that presents an obstacle, which clearly, obviously it does. And it's been something we've been talking about since August of last year. And we know there's at least one accountant out there. We've asked for other information. We've been conferring about workarounds, not trying to be unreasonable here. But here we are in July and we're not much further along. And the second objection, which I'd like to address, is very similar to the objection earlier this week about the cause number. And he doesn't cite any authority, but the brief argues that, well, there's no duty to respond to these at all because the case number and the style of the discovery requests was incorrect. And we got that late last night. I pulled a little bit of case law this morning that I wanted to share on that point. And it goes to waiver. For example, here is a case from the Texas Supreme Court that I was looking at this morning, talking about a motion for new trial that was misfiled, wrong case, misnomer, however you want to characterize it. And in this instance, the Texas Supreme Court referred to that as a non-prejudicial procedural defect that didn't preclude that situation from going forward. Here's a second case talking about service under Rule 21A. And we have here that we're talking about different types of service. And this is a case from Beaumont citing Texas Supreme Court, saying that when you attempted service pursuant to Rule 21A, achieve actual timely delivery to the proper party in a manner that accomplishes the objective of the rule and no harm is shown, courts have found adequate service. So what we have here are some legal principles that there isn't any further reason to argue about what was or was not in the case style. Service was effected in March. There's no denial there. We conferred prior to their responses. They responded. They've since supplemented. We filed a motion, set this for hearing. I don't think there's any legitimate argument that a typo in the case style somehow precludes any obligation on behalf of the estate to file prompt answers that comply with the rules. Even if there was such an argument, the time to object to that was in April of 2026 when these responses were due. And so I think we have an issue there with waiving any such a...
Hold on. Question.
Yes, Your Honor.
Question. Were the responses that Mr. Jones filed
Were the responses that Mr. Jones filed in the wrong cause number?
Or the correct cause number? And you have a terrible echo.
Or the correct cause number and you have a terrible echo.
They were filed
I can't get the record. Sorry. Time out.
I can't get the record.
Mr. Hammock, stop.
Sorry. Time out. Mr. Hammock, stop.
Your technology problems.
You're
not allowing me to ask you questions and her to take a record.
Not allowing me to ask you questions and her to take a record.
Okay.
You have two lines open, so we have a terrible echo.
You have two lines open, so we have a terrible echo.
Okay, just a moment then. Let's see if I can...
Judge, to answer, we served our responses in the correct cause number.
We served our responses in the correct cause number.
Well, even with Mr. Jones. Thank you, Mr. Jones. I
That
appreciate
result-
that. Mr. Hammock,
Thank you, Mr. Jones. I appreciate that. Mr. Hammock,
Yes, Your Honor.
you have to turn off something.
Is the echo still there?
you have to turn off.
Well, now it's gone, but I can't hear you. So I'm going to listen to Mr. Jones, and I think you're forfeiting your right.
To listen to
Say
Mr.
anything
Jones,
else.
and I think you're forfeiting your right to say anything else.
Or I'm going to stop this
I'm-
hearing
say
because your
again,
technology
forfeiting
can't
your
get
Or
your
I'm going to
technology
stop this
right.
hearing
can't-
because your technology
record.
can't get your technology right. I can't. No
There's no record right now while he's unmuted.
Oh,
There's no record right now while he's unmuted.
I'm doing my best here, Your Honor. I don't know what the issue is. It wasn't a problem last time. Just a moment. I suppose give me 2 seconds just to disconnect and reconnect and see if that resolves the issue. Is that all right? Can you hear me or is that not working?
We can hear you. The issue is whether there's an
We
echo.
can hear you.
Okay.
The issue is whether there's an echo.
Is the echo still there? I am disconnecting and rejoining.
Okay.
I'm hoping that resolves the issue. It shows that I'm in the waiting room. So
Well, you can't be connected twice. Oh my God. I'm readmitting him. Can't hear you. Your mouth is moving, but no sound. I'm going to give you 2 minutes to figure this out, and then I'm going to recess this hearing and order you to appear in person. Which would be unfortunate because Mr. Jones, I've heard his argument and I'll hear yours, but I can't imagine that I'm not going to issue an order about this. However, since Mr. Hammett can't get his technology correct, right? I don't know what else to do. I suspect what's going on with Mr. Hammock is he doesn't have the settings for
Here we
his
go.
speaker.
Is that all right? Is the echo gone?
Yes.
All right. Thank you for your patience there. I was wrapping up there. Any argument that relates to a typo in the case style, I think, was waived when they acknowledged receipt and served their responses the first time around in the correct cause number, and also then the supplemental second time around in the correct cause number. This is precisely the type of non-prejudicial procedural defect that I don't think should permit or should prohibit this from proceeding and us moving forward. So thank you, Your Honor.
Mr. Jones.
Yes, Judge. I'll make it brief. As Mr. Hammock mentioned, my client is elderly. She is the surviving widow of Mr. Buffington, who ran the business entities at issue. He died prior to a 2021 sale date of the company. That's really where all the money comes from that's at issue. The long and the short of it is Mr. Buffington, before he died, signed a pledge agreement agreeing to pay certain monies to Mr. Hammock's client. The business then sold after Mr. Buffington died, and there has been disputes left and right about the proper calculation of the distributions. That was the subject of the 2021 lawsuit that was filed, and that's the subject of the current lawsuit that has been filed. We are working diligently to try to provide as much information. I certainly understand 18 pages of documents is not a ton. That is what I have been able to locate. Ms. Buffington is in her 80s, was not involved, does not use a lot of the technologies that would generate a lot of email traffic or things of that sort. But we certainly are, we're not withholding any information. I've told Mr. Hammock repeatedly, as soon as I get something, I will give it to you. I
understand and I appreciate the difficulty you're finding yourself in. It does seem to me, unless you just tell me there's something wrong with Mr. Hammock's timeline, that he has been more than patient in trying to work with you about this.
I don't disagree. The discovery requests were served in, I believe, March. We reached out to get an extension. We just weren't able to connect due to schedules. So we served our initial responses in April, saying we're trying to figure out how much money was paid to the estate that would be subject to the pledge agreement. We then were able to get the distribution schedules that actually show exactly how much money was distributed to the estate. We provided those to Mr. Hammock and continued to work, right? They filed their motion to compel, continued to search for documents, supplemented in advance of the hearing on Monday, provided some additional documents. My understanding from conversations with Mr. Hammock is what really would be helpful are, bank documents showing monies hitting account, some additional level of verification. And I've been working diligently this week to try to get those and anticipate that I can get them relatively soon.
So then if that's okay, I appreciate first, and I'm sorry, I can't find my docket. I have the wrong cause number pulled up again. What is the correct cause number?
Yes, Judge, it is D1GN 25005042.
For what?
42.
Thank you. I'm sorry the docket we had printed out again and had the wrong cause number. I appreciate that, Mr. Jones. And, I appreciate that it may be that really your elderly client may not be the best person to get these from, but what would be, let me just cut to, I haven't seen the response you filed, but if part of it is that, I think there is a waiver. You clearly knew about this. I heard that on Tuesday from you. You filed responses. So,
The comment to that effect was not intended to argue waiver. We responded. It was to show, look, despite that issue, we responded in good faith. We're trying to participate here. I'm not trying to be, as I mentioned last time, I try really hard not to be a difficult person to work with, Judge. It's just taken longer than.
Well, so what's wrong? And again, I kind of understand this, but given the timeline and how accommodating he's been, and you're trying, maybe you just need a little deadline that you can show somebody so that you can get it done quicker. Or maybe
Yes,
somebody will let him talk to the accountant or whoever's going to know.
Yes, Judge. To that end, I would say I know Mr. Hammock requested an order within 10 days. I might just request an order by August 14th as a deadline. That just gives a few extra days. That would be 2 weeks from today's date to ensure we have time. But as soon as I get them, I will provide them to Mr. Hammock. This really, I believe, is a case we can get resolved. We just need to get information to satisfy Mr. Hammock's client that the numbers are the right numbers.
One more question for you. I'm not offended by 10 to going to 14 days, and I doubt Mr. Hammock would be either. The other question is, do I need to rule on those objections that do look like prophylactic objections?
We can amend and withdraw any objections that might, that don't need to be there. We're
here now, so do we need to go over them and see if there are any that actually need to be ruled upon? That sounds like, respectfully, I know how lawyers are, we'll withdraw any that don't need to be there.
Yeah.
If they don't need to be there to begin with, I will just say, as a general rule, as a practitioner, as a judge, I really don't like prophylactic objections.
Yes, Judge.
That's what makes litigation more expensive than it should be, and what makes people not like lawyers.
Yes, Judge. I will say there are some that I do not believe are prophylactic objections. For example, there are some requests that ask for distributions without limiting distributions that would be subject to the pledge agreement, right? They're asking about, we want to know about all monies that you've ever received from anybody. And I'm like, well, that wouldn't be relevant to how much.
Well, what if I do an order that says we clarify that to distributions related to the pledge agreement?
Perfect. Yeah. We've tried to answer in that vein of here's everything that would be related to the pledge agreement. That was the intent.
So I want to know, if we have an order that limits his request to distributions related to the pledge agreement, are you going to withdraw all the other objections, or do I need to go over them?
We will withdraw, Judge.
Excellent. Thank you. Mr. Hammock, let's do an order today and get this done.
Will do.
14 days. So whatever that is, August 14th. Is that what you said? 2 weeks from today?
In the correct cause number, Your Honor.
In the correct clause number. Yeah. Okay. And Mr. Hammock, you're also given an order from the court to figure out your technology.
And you're not kidding. I'm going to go figure this out. I appreciate
I'm going to
your
make a
patience.
docket note that says, and so if you have any more Zoom hearings, I'm going to leave a docket note that says your technology caused this hearing to take twice as long. And if you show up again with bad technology, the judge should just reset you.
Understood, Your Honor. Thank you for that.
Okay. All right. Anything further?
Nothing further. Thank you, Judge.
Thank you all. You all may be excused.
Have a great weekend, Judge.
You too. Thank you.
What should have been a routine legal hearing quickly became a battle over paperwork, deadlines, and missing financial records. Inside the courtroom, Attorney Dave Hammock appeared for the plaintiffs, seeking answers from the estate of Tom Thomas Buffington. But before the judge could hear the motion, a problem surfaced. The motion to compel had been filed under the wrong case number. Defense attorney Austin Jones argued that the old case had already been closed and that the court could not issue orders in a completely different lawsuit. Hammock admitted it was a clerical mistake, but argued that everyone knew exactly what motion was being discussed and that no one was harmed by the error. After sorting through the confusion, the judge allowed the hearing to continue. But the bigger dispute remained. The plaintiffs wanted financial records proving how much money the estate received. The defense explained that gathering documents was difficult because Delia Buffington was elderly and had limited access to records. After months of delays, the judge ordered the estate to provide the missing information within a set deadline. A wrong case number, a tense Zoom hearing, and a financial dispute that refused to disappear.